reduced it to writing in an order prohibiting in-court identification and descriptive testimony. The order also prescribed the Commonwealth from eliciting and Sanchez from making any in-court identification of the defendant during his testimony at trial. We had a full evidentiary hearing back in December, which included testimony from Mr. Sanchez. This court found the influence of suggestive images and media on Sanchez's recollection of certain details of the physical characteristics of the alleged shooter to have been, in this court's words, quote, substantial and undeniable. This ruling was based on Your Honor's evidentiary finding that Sanchez's initial recollection of the alleged shooter's physical characteristics had been affected by significant media coverage of Mr. Hernandez's arrest in an unrelated case. As a result of Mr. Sanchez's exposure to these highly suggestive images and media related to a different offense, embellishments of Mr. Sanchez's recollection of the alleged shooter had manifested itself to include a so-called refreshed memory of additional physical attributes of the shooter that were consistent with physical characteristics of Mr. Hernandez. Now, in resolving whether Sanchez's testimony, once determined to have been tainted by suggestive media and so forth, this court applied the well-established test by our Supreme Judicial Court in Commonwealth against Johnson. Your Honor highlighted, and I quote, "The danger of unfair prejudice arises because the accuracy of an identification tainted by suggestive circumstances is more difficult for a jury to evaluate." End quote. The court continued, quote, "Measured against the probative value of Sanchez's enhanced descriptive testimony, you held that the danger of unfair prejudice to the defendant is substantial." End quote. Now, in clear and patent violation of this court's order, the Commonwealth, during its examination before the jury of Mr. Sanchez yesterday, March 9th, 2017, elicited testimony from Sanchez that included an in-court identification or the functional equivalent thereof, and testimony about the physical description of an alleged shooter beyond the parameters established by the order prohibiting in-court identification and descriptive testimony issued by this court in January. In response to a question for which the court admonished the prosecutor for having been leading, Mr. Sanchez testified that the alleged shooter was, quote, "white, just like him," where him was followed by a knowing look and a head nod in the direction of Mr. Hernandez to make clear that Sanchez's him referred to Mr. Hernandez, who was present in court and well in view of the jurors. Now, this verbal statement by Mr. Sanchez, "white, just like him," as well as his nonverbal physical gesture, constitutes an in-court identification that jurors received and perceived as the witness having identified Mr. Hernandez as the alleged shooter. Indeed, this very thing was reported widely on the media yesterday. This testimony is the exact type of testimony that Your Honor's order prohibiting in-court identification and descriptive testimony prohibited. The matter is made even worse by the fact that Sanchez's response, "white, just like him," came as a result of the Commonwealth's repeated questions of Sanchez about physical characteristics of the shooter, when the Commonwealth simply could have let the audio stand. That was the agreement. Play the audio, that was the description. The Commonwealth did not have to ask additional descriptive questions. It did, and that elicited the improper responses. Shortly after the witness's improper in-court identification in violation of this court's pretrial order, the Commonwealth asked the witness multiple times to recall whether in his pre-June 2013 statement he remembered the alleged shooter to be, the Commonwealth's words, to be, quote, "black, white, or Hispanic." Now, while Your Honor's order limited Sanchez to providing details of the physical characteristics of the alleged shooter consistent with his statements prior to June 13, these statements included the alleged shooter was white or light skinned. The prosecutor's inclusion of black or Hispanic in a leading question, unnecessarily confused the issues and set the foundation for Sanchez to give a response in patent violation of this court's order. In response to the prosecutor's question, quote, "Did you say white, black, or Hispanic on the tape?" Sanchez first answered light-skinned. That is well within Your Honor's January order. But the Commonwealth did not stop there. As a follow-up, the prosecutor sought to further clarify Sanchez's response and asked, quote, "You said white." Sanchez replied, "Yeah." This is a quote, I'm sorry, Your Honor. Sanchez replied, quote, "Yeah, looked like Spanish, light-skinned," end quote. Now, while the, quote, "yeah" affirmation of this description of the alleged shooter as white represented a statement within the bounds of Your Honor's order, Sanchez's supplement of the statement that the alleged shooter looked Spanish, quote, "looked Spanish," end quote.
I'm sorry, hold on. What are you quoting from?
Quoting from the transcript, Your Honor.
Can you give me a reference to the transcript page and line? Is this the transcript that... hold on one second, Ms. Sullivan. Do they have a different transcript than what you prepared for me? No. Okay. Now, the transcript, I think, is 6 pages of text.
Yes.
What page?
So the first one is page 4.
No, what you just referenced, sir.
This is page 5, and I see what I just referenced was a quote from the from watching the video. I'll supplement my remarks with a quote from page 5.
So it's not from the transcript.
Not from the transcript, but the same effect. The transcript has at line 21, page 5, "but black Spanish, light skin." Of course, there was a timely objection and a move to strike. Your Honor overruled the objection. We would like to put in evidence in this hearing the actual video of Mr. Sanchez because everything was not caught on this in the transcript, but it's clear.
What do you mean? What do you mean everything was not caught?
Well, he says, "I'm not stupid, man," very clearly on the video. On the video, he says, "Spanish, light skin." This looking like Spanish is what I quoted. He says it very clearly on the video, and if Your Honor permits, I'm happy to play the video as well, just for the record, and just so that we have a record on that.
All right. Why don't you offer the video?
Very well.
All right.
We'll have our people put it on a thumb drive very quickly, Your Honor. Would Your Honor like to hear it?
No, I want it. You just said you'd offer it. I said I'll receive it. Now you don't have it?
We have it. Yes, we have it. We're putting it on a thumb drive. Now, but it is clear both on the transcript that he said Spanish, black Spanish. There were timely objections. On the video, it's clear he said looking like Spanish. For the record, Mr. Hernandez is Hispanic. That is, quote, like Spanish descent. This is another instance of the exact type of testimony that Your Honor's January order prohibited. Those are the facts. Very briefly, Your Honor, the law. The law is clear that where a jury is exposed to inadmissible evidence as here, the judge may, quote, correctly rely on curative instructions as an adequate means to correct any error and to remedy any prejudice to the defendant. This is in the Aramalt case, 404 Mass 221, 1989. However, the Supreme Judicial Court has held that that is the case as long as the judge's instructions are prompt and the jury does not hear again the inadmissible evidence, then in that case a mistrial is not necessary. The court has defined prompt, however, as an immediate curative. In Commonwealth v. Roe, by contrast, And in a case with striking similarities to our case, the Supreme Judicial Court overturned a conviction where the witness provided testimony to the jury about a matter that had been excluded through the defendant's motion in limine, just like in our case, upon a finding that the judge attempt to give a curative instruction the day after the inadmissible witness testimony was received was insufficient to avoid unfair prejudice to the defendant. And Roe is 90 Mass App Court 801. Prompt was defined not as sufficient the day after. And we submit that at this point, after raising the objections immediately, real time, coming to sidebar.
Well, no, you didn't.
Well, the transcript says, Mr. Baez, objection, judge, move, I'm sorry, transcript page 5, line 23. Mr. Baez, objection, judge, move to strike. Line 25, the court overruled.
I thought you were referencing the phrase "just like him," which you equate to the functional equivalent of an identification.
There are two violations. One, the just like him. The second is the Hispanic.
With regard
comment.
to the "just like him," which you are stating is now reported in the media.
And just like him is on the transcript, page 4, line 22.
Yeah.
And directly after line 23, Mr. Baez objects again to the leading nature of the questions.
On where is that, sir?
This is page 4, lines 22, 23.
Yep.
And what we do not
23.
have...
That's the only objection, though.
No, Your Honor. Page 5, there's an objection.
On page 4.
That's the only objection
The
on page
only
4.
asserted ground for the objection was the leading nature of the Commonwealth's question, correct?
That is not the only objection. We came to sidebar. We don't have the transcript to that.
You came to sidebar after
We came to
this
sidebar.
testimony.
We came to sidebar after.
And would you agree that when you came to sidebar, you requested orally a mistrial?
We do, on
And-
the grounds that I'm articulating
Yes, I know.
presently.
And I indicated I wanted to see a transcript of the testimony before ruling.
I think that, I disagree. I think that Your Honor said, I did not hear that. Ms. Kenny Bodden was very express that this witness said, like him, Your Honor said, I did not hear that.
Did I say that I wanted to order a transcript?
You said that as
Before-
well, in addition to saying that you did not hear that.
And which is why a transcript would be helpful, correct?
We then went to lunch, Your Honor. We came back to sidebar. We don't have that transcript, but I want to make a full record. And I move for a mistrial orally on behalf of Mr. Hernandez based on now both of the statements that we had ascertained that this witness made improperly. Your Honor said that you thought he was referring to skin color. And the light skin comment we concede is well within Your Honor's order from January. The Hispanic comment is plainly outside of the order. So we submit that we made timely objections in both instances at sidebar twice yesterday.
Well, that record will speak for itself. Anything further?
I do, Your Honor, just want to, I think I said for the record, the Roe case with respect to a day after not being prompt.
Prompt.
Yes. And so we think a curative is not available here. Now,
So I take it if I deny a motion for mistrial, the defense is not requesting any curative instruction.
we will make an evaluation and talk with our client if Your Honor, I cannot make a representation at this point prospectively. We are asking for a mistrial.
I understand that, sir, but I'm asking if I deny that request, then promptness seems to be at issue, at least in your mind, and the longer you all confab, the less prompt any response might be.
I have no further representations on that. We'll discuss it with our client, but we will not accept responsibility for a delay on this because we raised this timely yesterday, and the court did not act.
I understand, sir, but you are not asking for a curative instruction at the beginning of today's proceedings.
I'm not asking for a curative at the beginning of today's proceedings.
Okay.
I need to discuss that with the client to the extent Your Honor decides to, if Your Honor decides to deny. We have done, and this was quick, Your Honor, last night, so I'll preface it by saying it's a non-exhaustive review of Massachusetts appellate and Supreme Judicial Court cases where lower court decisions not to grant a mistrial were upheld following exposure of jurors to inadmissible testimony or, like in this case, previously excluded prejudicial evidence. The lower court's prompt curative instructions were issued immediately after the statements were made upon the court's sustaining of a defense objection. And I listed, I'm not going to read them, I listed cases in the papers. Here, the court overruled defense objections to these instances of testimony being introduced contrary to this court's own order in limine. Jurors were not provided a curative instruction during the witness's testimony. The witness provided an additional inadmissible and highly prejudicial statement contrary to an order in limine after defense objections to the witness's first inadmissible statement, and jurors were ultimately allowed to go home for the night to think about and ruminate on the witness's inappropriate in-court identification and description of the defendants of Mr. Hernandez without any cure. Now, so we submit that a curative instruction at this late stage cannot be deemed prompt as a matter of law, and moreover, it is insufficient to mitigate the gross prejudice visited on Mr. Hernandez in this case. Your Honor, we have the, it's now prepared. We have the testimony for Your Honor to
No,
hear
I don't
exactly
need
what
to
he said.
see the testimony. You may offer it as part of the record if you want to offer the video on a thumb drive.
I'll offer it then, Your Honor, as part of the record on the thumb drive.
And Ms. King has made an official transcript of a portion of the testimony at issue now.
In that
right.
case, Your Honor, we certainly take issue with the transcript, and I will move at this point to amend the transcript consistent with what was actually said in court. And with leave of the court, I'll find the doctrinal support for such a motion, but I do want to make this motion promptly. We have the benefit of this hearing being televised and the benefit of seeing exactly what Mr. Sanchez said. It is our position that to rely.
Offering that.
It is our position that to rely on the transcript when it is plainly inconsistent with what the witness said from the witness stand is the rank elevation of form over substance and violates Mr. Hernandez's due process rights even more.
Then offer the thumb drive.
Yes, we are, Your Honor.
Will do.
Would you give us 1 minute to finish downloading it?
All right, let me hear from the Commonwealth.
Thank you, Your Honor. The Commonwealth suggests that the defense argument is not only inaccurate, it's disingenuous and quite frankly offensive. Just calling the court's attention back to how this all began, I think all of the parties, including Your Honor, recognize the rather unique position that the witness, Mr. Sanchez and Mr. Ferrer, were placed in, as well as the Commonwealth, where they were not allowed to testify truthfully under oath as to their current memories of the event, and they were going to be limited to what they said back then.
I object to that characterization, Your Honor. Truthfully under oath. The point of Your Honor's order was that it was not truthful. The point is that he was tainted because of media bias. I find it offensive that Mr. Hagan now stands here and tries to articulate what this witness said and what this witness would say as the truth. It wasn't the truth. It was a lie. That's why we moved to have it suppressed. That's why I submit, Your Honor, granted our order. I apologize to Mr. Hagan for interrupting, but he's being prejudiced every day in this hearing. And I cannot stand idly by in good faith as his advocate and allow these sorts of statements to go unchallenged. It's untrue, Your Honor. It's untrue.
May I continue, Your Honor?
Are you done? Commonwealth.
Your Honor is aware that we had multiple conversations at sidebar where the Commonwealth talked about the issues involved in making sure that the witnesses did not say anything beyond the court's order. I believe Your Honor specifically said, and counsel even agreed, to the best of my memory, that the court would give the Commonwealth great latitude with leading questions to ensure that no witness violated the court's order. The Commonwealth multiple times advised the witnesses of the limitations of their testimony. So fast forward, Your Honor, to yesterday, where the Commonwealth attempted to introduce, not as an exhibit, but as a chalk, a transcript of that recording. Now, I ask Your Honor to keep in mind that Mr. Sanchez has a rather thick accent, and sometimes his words are difficult to understand. The purpose in the Commonwealth attempting to have a transcript by which the jurors and all the parties could read as they're listening to the statement from 2012, so that, again, they could understand what's being said. Defense counsel, again, in a move I suggest is disingenuous, objected to a transcript that they've had for months at the very least. They objected to jurors being allowed to sit there and read as the witness spoke. The Commonwealth withdrew the motion. We had the testimony played, or not the testimony, the statement played by Mr. Sanchez. The Commonwealth was very direct and specific in what it asked for follow-up questions, and it was very much related to things that the jurors may not have heard or understood from his accent. I would call Your Honor's attention to this transcript where every single time I asked a question of Mr. Sanchez, I started with the words, "in that statement." The limitation, the qualifier, in that statement. And I first clarified, in that statement, what did you mean by the word rag? And of course, as Mr. Sanchez started to speak at length, I tried to stop him so he wouldn't violate the court's order, and the defense counsel objected and insisted that he be allowed to answer the question fully. Again, opening the door to some tainted information coming out. Following that, I simply asked the witness in a very direct and leading way that should require a yes or no answer. Sir, in that statement, did you indicate that the shooter was white? And Mr. Baez has the audacity to get up and object for leading to that question. And that's the point where my recollection is Mr. Sanchez, when Mr. Baez stood up and objected for leading, which of course sustained, that's when Mr. Sanchez said, yeah, like him. Then, counsel again has the audacity to suggest that it was improper for the Commonwealth to then follow up. Did you say white? They object again on leading. So the Commonwealth tries to ask a non-leading question by saying, okay, in that statement, not now, in that statement, did you describe the person as white, black, or Hispanic? Again, the Commonwealth attempting to not lead, as the defense was objecting to, and that's when I think in response to those questions, eventually, over and over again, Mr. Sanchez eventually said white Hispanic or something to that effect. The Commonwealth has gone through great lengths in that testimony to ensure that nothing beyond the scope of the court's order came out. And again, I suggest that for counsel to imply or outright state that the Commonwealth violated that order is, again, false and disingenuous.
All right. Based on the official transcript, I don't find that the Commonwealth engaged in prosecutorial misconduct in any way or structured an examination in a way to elicit from that witness, Mr. Sanchez, testimony that I excluded. I will say, in response to the defense argument, that the court in its earlier memorandum made no finding on the truth or falsity of any witness's description evidence or identification evidence. Rather, the court focused on reliability and on the developments in Massachusetts law in the last several years regarding identification evidence. It also seems to me that to the extent there have been any reports that Mr. Sanchez made any form of identification of Mr. Hernandez, that is a mischaracterization of the evidence that was heard yesterday. What Mr. Sanchez said yesterday was comparing skin color or skin tone to Mr. Hernandez in the gratuitous response that the skin color was light-skinned just like him. So at least on the transcript, I don't see a basis for mistrial, but once the defense offers a thumb drive. I will view that at some point later on. Mr. Sullivan, you've now just handed that up.
That offered?
Offer the thumb drive depicting what the witness actually said.
Let us make it the next lettered item for identification.
Can I have the scissors, please?
Then for the record, Your Honor, can we have clarity on?
No, hold on.
Hold on.
All right, now I will review that before endorsing anything on a motion.
Brief indulgence.
Now, no, I want to focus on something else at this stage.
Well, we need clarity on which orders the Commonwealth follows and which they're not.
Mr. Sullivan, no, I've heard your argument. I have your motion. I've heard the Commonwealth's argument. I'm going to review the video, compare it with the transcript, and make an endorsement. I want to focus on the issue of so-called gang affiliation or gang evidence that arose yesterday. Mr. Baez, I had asked for a written proffer on that issue, setting forth whatever connecting links you might see between gang evidence, so-called, and this case, either under a third-party culprit claim or under a Bowden claim. I haven't received anything. Does the defense have a filing for the court?
We do not.
Is it the defense's intention or desire to pursue a Bowden claim as it relates to gang information or connections?
I think that the defense is freely entitled to question Detective Cummings about his notes that reference gang member activity and what he did about it. I think that's the extent of what we're willing to do at this time. If the court's willing to accept Mr. Sullivan's answers yesterday during the proffer, that those fingers are just him hanging around having a good time, or words to that effect, or that's just...
That is the testimony, sir.
I realize that.
Now, tell me why that's inaccurate in some way, and I asked for that showing in writing. I think Mr. Leontier indicated that he had the cover of a book on Cape Verdean gangs depicted on his laptop, but that isn't quite sufficient to make some showing. But why don't we do this? As it relates to a Bowden issue, the right to pursue the thoroughness or completeness of the police investigation, it would be appropriate, I think, to have a voir dire with Detective Cummings as to what that reference is in his notes as you presented it to me yesterday. Let's see what that meant. All right, let's have Detective Cummings in. Double A. Counsel, for those keeping score, the thumb drive that has been received is marked double A for identification.
Okay, so one step else. Thank you very much.
Good morning, Detective.
Good morning, Your Honor.
You recall, sir, you were sworn yesterday and you remain under oath today.
Yes, Your Honor.
Thank you. Mr. Hagan?
Good morning, sir.
Good morning.
And, just for the record, just state your name again for the record.
Detective Joshua Cummings.
Detective Cummings, I'm going to call your attention now to a specific page of your notes. May I approach a witness, Your Honor?
You may.
Detective Cummings, I'm showing you a photocopied document. Do you recognize that, sir?
Yes,
What do you recognize that to be?
it's a copy of a page from my notebook.
Your Honor, that the copy of the page from the notebook be marked for identification purposes here. No objections.
That will be.
And Detective Cummings, calling your attention now to the last two paragraphs or sentences of what's been entered now as Exhibit BB. Can you read to us the beginning of the second to last sentence?
Safiro involved in drug dealing in Cape Verde, question mark, conflict, question mark.
And what did you mean by that, and what was the source of that information, if any?
There's a rumor that was out in the community. There's several in cases like this, so I was aware of it and wrote it down.
And when you say a rumor in the community, can you elaborate on that a little bit? How did you get that? How did that rumor come to you?
I believe at that time this was something that I heard through some other policeman that said, hey, I had heard this. Sometimes people try to help in our investigations. I heard this and passed it along.
So again, was this something that you knew of a named source that you could speak to?
No.
Calling your attention now to the second sentence, which ultimately was the last sentence on that page of your notes. Can you read that, please?
Someone after Rashides and Gerson may be involved with CVO.
Now, when you said that, what did you mean? Did you mean that Rashides and Gerson may be involved with CVO, or did you mean the person after them may be involved in CVO?
That the person after them may be involved with CVO.
And just for purposes of the record, what is CVO to your knowledge?
It's a group here in the city of Boston, the Cape Verdean Outlaws.
What was the source of that information, sir?
Again, the same type of rumor.
So it was someone in law enforcement perhaps telling you what the word in the community was?
Well, not perhaps.
Well, tell us, give us some more details, detective, as to where that came from.
Again, these are things that people here in the community, particularly members of the gang unit, and they will pass them on. They're not specifically ascribed to a specific person. It's we're out, we're working in the community, here's what we're hearing.
Okay, so that's what I need some clarification on. So, to your knowledge, was this a confidential informant speaking to gang unit officers and that officer passing it on to you?
It was not.
What was it instead?
Someone in the community. It was not from a confidential source. It was not from some source they used or were very familiar with.
And to the best of your knowledge, Detective Cummings, was there any way that you could follow up on that street rumor?
Yes.
And how was that?
We went through the databases available to us and we looked into our victims to see if they had been stopped with known gang members, if they had been, their movements had been noted in these areas, if they had any sort of criminal record, arrests with gang members, things like that.
And in addition, did you talk to any officers that even knew some of the victims?
I did.
And what was the information conveyed from them?
That these young men in the car were not gang members, that they did not have gang history. This was from an officer who is of Cape Verdean descent and knows the community quite well, and said that these things that you're hearing simply aren't true.
So Detective Cummings, as I understand it, correct me if I'm wrong, you've described your own efforts to ensure that the victims and survivors were not gang members, correct?
It wasn't to assure whether they were or not. It was to verify, is this true or is this not true?
Right, and that was things you did on your own out with additional information, correct?
Correct.
But as far as being able to follow up on the, as you described, rumor on the street or in the community, was there anything you could do to track down that rumor?
Beyond what I did, no.
Thank you, Detective. I have no further questions.
Ms. Bias, before you begin, let me just clarify. The rumor came through, was it the gang unit?
I believe it was it would have been a member of the gang unit or the drug unit, people who work closely with those communities, Your Honor.
And that would be a member of the Boston Police?
Yes, sir.
Okay, thank you. Mr. Bias, please.
Thank you, sir. Good morning, sir.
Good morning.
Another police officer told you that Safiro Furtado was involved in dealing drugs in Cape Verde.
No.
Okay. He told you that he heard this.
That this was something that people were talking about in the community.
Okay, so another police officer told you this.
Another police officer told me that he had heard this rumor out in the community.
I understand that.
He did not present it as fact.
I understand that, but I want you to listen to my question. This information that you got here about Safiro Furtado,
Yes, sir.
you got from another police officer.
Yes.
What is his name, sir?
You know, at this time, I can't remember his name. This
Did
was
you
a
write
member of the
down
gang.
his name?
No, I did not.
So you have information about a possible drug connection in this case, and you decided not to write it down.
No, sir. I had someone who passed along a rumor that they heard almost third hand, which is not the same as saying I have information about drug dealing or a drug dealer.
Let me ask you this. Safiro involved in drug dealing in Cape Verde.
Question
Conflict.
mark.
Is that information or is that nothing?
Again, if you read it as it's written, it says Safiro involved in drug dealing in Cape Verde, question mark. This is something that was thrown out. It was not thrown out that someone said, I know that he is. It's not someone who said there are records that he is. This was a rumor that's thrown out. They are
I'm
thrown out
not
in these
asking you if
cases
it's
all the
true.
time.
I'm not asking you, sir, if it's true. I'm not asking you if there's any substance to it. I'm asking you if this is information. As it's defined, information.
As it's defined as information,
Yes.
this is something that I heard in the course of an investigation.
And you thought it was important enough to write down.
Yes,
Okay? But yet, you didn't find it important enough to write down where you got that information from.
no,
Okay? And then, you certainly didn't ask where that person got this information from.
it was relayed to me this was simply something they heard.
Okay, let me take this. If I, as Mr. Hernandez's lawyer, wants to know the source of this information, I need to go to that police officer who you don't even remember their name, right?
I suppose.
Okay, and then I have to go to this faceless police officer and then ask him where he got his information from,
Yes,
because that's something that you did not do.
yes.
Okay. Now, as it relates to someone after CVO, someone after Rashides and Gerson may be involved with CVO, who gave you that information?
Again, I believe it was probably the same source.
The same source for which you have no idea who it is, what police officer, this faceless police officer.
Correct, sir.
Okay, so this faceless police officer gives you this information as well, and you find that important enough to write down.
Yes,
Okay, but yet you don't find it important enough to not only write down his name, but the source of where he got that information.
since he never gave me the name of a source where he got the information, I simply couldn't write down that name. I did find it important to write down and to follow up on. What I found was nothing.
Let me ask you this. Did you note down here when this officer came about this information?
I don't understand the question.
When this officer got this information?
It was after the incident.
I understand that, but when specifically?
It wasn't specific in nature. That was the problem with the information on its face. I heard this. He didn't say I heard this yesterday, an hour ago, I heard it from this person. I heard this. That's what happens in these investigations.
And did you ask him that?
Ask him what?
When he heard this information?
I didn't. I assumed it was shortly before he called me with it. It may have been a day or 2 days, but I didn't ask him specifically, did you hear this in the last hour, 15 minutes? When did you hear it?
Well, it may be helpful if you can tell us when you heard from this officer in relation to when the shooting was.
I believe it was shortly after the incident, Your Honor.
Well, what does shortly mean?
I would say within the first week, 2 weeks.
All right.
After getting this information that Safiro Furtado may have been involved in drug dealing in Cape Verde, did you then go and seek out any possible criminal history of Mr. Furtado in Cape Verde?
I did not. I may have been done, but I did not.
Okay. And as it relates to Mr. Rashides Sanchez, did you do that?
Did I do what?
Get a possible criminal history check of him back in Cape Verde?
There was nothing about him in criminal activity in Cape Verde, so
Did you do a criminal background check on Rashides Sanchez in Cape Verde?
we did one on them on what was available to us. I do not believe we contacted the authorities in Cape Verde.
Okay, that's a little. I'm a little unclear on your answer. Is
So
it
we
yes or
did.
no?
I have access to
I need ask
Massachusetts
the question,
databases.
sir.
One at a time, you want to
Yeah, I need to ask the question, sir. I think this is not your first time testifying. Please let me finish. Now, as it relates to Rashides Sanchez, did you do a criminal background check, on Mr. Sanchez in Cape Verde?
No,
Did you do a criminal background check on Mr. Gerson Lopez in Cape Verde?
Gerson Lopes.
Gerson
No.
Lopez. Lopez.
Lopes.
However you want to pronounce his name.
Gerson Lopes. No.
Okay. So despite having this information, you still didn't do a follow-up of that kind.
That kind of follow-up really wasn't available to us. We did the follow-up that we could do based on things here in the United States.
I'm aware of that. Now, you mentioned that you did a database search to see if any of these individuals were stopped with known gang members, right?
Yes, sir.
Now, that would be limited based on how long an individual has been in the United States, right?
Yes.
If they take the train, they're certainly not going to get stopped, right?
No, sir. They actually could.
And of course, the less amount of time that they've been in the country, the lesser the chances that you are going to be able to find out if they're even in this database.
I would say that's not necessarily true, no.
Okay, well, are you saying the longer are you saying if a person's in this country just a few months, that doesn't decrease the likelihood that they're going to be in that database versus they've been here for years?
What I'm saying is if they're hanging out with known gang members, they could be stopped. There could be reports written. I looked into these young men, and the answer was no.
Do you know how long Safiro Furtado was in the United States, sir?
I believe a few months.
Okay, so in just a few months, he would have had to have been stopped with gang members to have been in that database.
And typically, gang members do get stopped even in that shorter period of time, and he wasn't.
Okay. And that's something that you have statistics on?
It's not about statistics. It's
So the
about
answer to
whether or
my
not
question
he
is
was.
no?
It's not about statistics. Whether he was stopped or he was not. He was not.
My question to you, sir, is you have statistics on how long it takes for someone to enter the country, join a gang, and then get stopped by the police.
I don't believe anybody has those kind of statistics, sir.
So the answer to my question is no.
Yes, the answer to your question is no.
Now, sir, did you do any FBI background checks to see if they had any criminal activity or backgrounds in other jurisdictions
When you say other jurisdictions, what are you referring to?
outside of the state of Massachusetts?
Well, it's my understanding, as you just pointed out, he was here for 3 months here in Boston, so he couldn't.
He couldn't travel to another state?
Well, in that short period of time, I had no information that he had ever traveled to any other state. What you're referring to is a triple I check, which I believe was not done by me. I believe was done, and again, turned up nothing on these young men.
My question to you, sir, if you please listen to the question, is did you run a background check on them with the FBI, the triple I check?
It was either done by me or a member of my squad. I don't have a specific memory of doing it, but we do talk. I know that it was done, and there was nothing found.
So the answer to my question is you can't answer that because you don't know.
No, my answer to your question is it was done, and the answer is no.
You did this?
No. If you listen to my answer, sir, what I said was, I am aware that it was done. I don't have a specific memory of me doing it, but it was either me or another member of my squad would have done it. It was performed. There was nothing that came back. So the answer is no.
If I can have just a moment. Sir, did you write a report saying that you did a triple I check on this case for
No.
these individuals?
No, I did not.
Have you read a report by another officer stating that a triple I check was done on these individuals?
No, I have not.
No further questions.
Thank you, sir.
Yes, Your Honor.
All right, counsel, I am going to permit the defense to inquire of this detective as to the entries reflected in his notes, those entries that we've just heard and that were the subject of this voir dire.
Your Honor, may I be heard briefly?
Yeah.
I don't think the language from Silva Santiago could be any more clear or applicable to the current situation. Stated in the case, the Supreme Judicial Court, nor did counsel's proffer demonstrate that the probative weight of this Bowdoin evidence exceeded the risk of unfair prejudice. The, quote, word on the street, unquote, carries no indicia of reliability by itself, and defense counsel did not bolster it by showing that the word came from a percipient witness to the incident. I don't know how much more on point that case could be than what we have here. This is double, triple hearsay, word on the street, and the prejudicial effect on
Well,
the victim
no, we don't
in
know.
this case?
No, we don't know what this is. We don't know what its source is.
All the more reason it should be inadmissible.
No, we don't know that because the police aren't in a position to tell us who the reporting officer was and what the reporting officer's basis of knowledge was, whether it was pure barroom talk or whether it came from some identified individual. The defendant is not in a position to establish the reliability of the information because Detective Cummings can't tell us who the police witness reporting this was, other than he would have been an officer in a specialized unit, either gang or drugs. And so I'm satisfied that, well,
Your Honor, you
I
must-
cannot find that this is simply uncorroborated street rumor of second, third, fourth hand. I can't find that because we don't know who the reporting officer is or what the reporting officer's basis of information was.
Respectfully, Your Honor, I have a little bit different of a memory of Detective Cummings' testimony.
He made clear in response to my question that the reporting officer indicated to Detective Cummings this was not a source that told him this. This
It was not a confidential informant.
I think he even said it was not a source and that it was word on the street from the community. Classic rumor on the street.
So I think you can make a finding that there was going to be no indication of where this information came
No,
from.
I'm not satisfied that you've established that it was mere street talk. All right. At the appropriate cross-examination, Mr. Baez, I'll let you make that inquiry. And once made, the Commonwealth then has the right to respond to it and demonstrate the scope of any police investigation into that issue. All right, are we ready for our jurors, folks? I take that to be yes. Mr. Sheehan.
Yes, Your Honor.
Let's line.
All right, please.